matter of the city of Wyandotte versus Teresa Danes, 24137.
Right here. Good afternoon, Your Honor. Neil DeBloy here on behalf of Teresa Danes. It stands to my right. Would you state your name for the record, please?
Teresa Danes.
All right, thank you. Please remove your hands from your pockets. And so today is the date scheduled for sentencing on your client's plea to possession of controlled substance. The possession of drug paraphernalia and speeding charges were dismissed. And counsel, do you have an opportunity to review the report and recommendation? There's also a bond violation as well.
Yes, I'm aware of that. And yes, we did carefully go through the pre-sentence investigation report. And we have to comment.
Okay, and as for those comments, counsel?
All right. First of all, on page 1 of the PSI, it says under criminal history 11324 Southgate. I'm advised that that matter has been dismissed without prosecution. It's not pending, it's been resolved.
Yes.
Okay, you're aware of that. All right. In addition, the client advises are not included under her health conditions, treatments, or whatever it's called. She's recently been diagnosed with ADHD, is under pending doctor's care for that. She also has a long-term condition of psoriatic arthritis. Is that correct?
I'm sorry, I didn't hear what you said, ma'am.
She said yes.
Okay.
There is also no reference to the fact that she, oh, maybe I'm wrong about that. She does have one child at home. It is referenced, just pointing that out. She has one child at home. And she still take a minor child that she still is responsible for. And finally, a question only with respect to the recommendation or the plea, there was a question of whether or not she qualified for 7411. This is apparently the first time drug offense for her. There's no reference to that in the recommendation. That was part of the plea bargain eligible. So I don't know if that's been, she's not eligible or it just was overlooked, or
I may have just been overlooked as far as that goes, or maybe they're waiting to see what was going on with the Southgate matter. But it would appear that your client is eligible under 25.136B, which is the local ordinance equivalent of the 7411.
yes. So
Because there are not any prior criminal or prior drug convictions.
yeah, so again, to my review, it appears she's eligible. So we asked the court to consider that. With respect to other than in terms of factual modifications or amendments, otherwise the report is appears to be factually accurate. With respect to the recommendation, the circumstances and her eligibility for 7411, some additional information that I want to provide. She is in outpatient counseling with a program it's known as Work It. Is that correct? Work It, which involves, as I said, outpatient counseling. So she does have that assistance. It's also not.
And they randomly drug tested that as well.
Okay, and so what are your prescription medications?
I'm currently prescribed Provigil, and I don't have that yet in my system. So right now it only has positive Suboxone, which I'm prescribed for.
Well, okay, here's my question. So you claim that you're prescribed Prozac, Suboxone, and Trazodone.
Yes.
So you were supposed to have submitted proof of those, but you haven't yet.
Oh.
And that you also use, I'm sorry?
I'm sorry. I probably have them in the car.
Okay, you also use Kratom and marijuana.
Not anymore. I'm clean and sober now.
Very good, because Kratom is just a legalized form of opioid, pretty much. I mean, you take enough of that at one time,
Okay.
and it has opioid effects. And so, and I don't even think that that's actually even FDA approved or not. I don't know. I don't think it is. And then the more you take, then you take more and more and more and more. And so, okay.
And again, if I make it to your honor, with respect to the recommendations, the item 2 is incarceration. Don't know that that's warranted in this instance, or that it would do any good. I'd suggest the court court is inclined to order incarceration, that to be held in abeyance, give her an opportunity to, she said, prove that she has been clean and sober, and, revisit that in the future. That would be my request. Beyond that, it seems to be appropriate under the circumstances.
So, okay, I'm gonna hold off on. I guess, stop. Yeah, we'll finish these. All right, we're at the end of the bond violation. Ma'am, please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
I do.
All right, so you were ordered on bond on March 20th, not to possess or consume any alcohol or drugs unless prescribed, and to participate in random testing.
Correct.
Okay, so on March 22nd was your first test. You're positive for amphetamine, cocaine, marijuana, Suboxone. March 29th, positive cocaine, Suboxone, marijuana.
Well,
You're
level down.
I understand that,
Okay.
but now you've been given a prescription for cocaine.
No, but I told you in court that day that I
So-
would call the test for that.
Well, it wouldn't be that way 9 days later, ma'am.
Honest to God.
You failed to appear on April 15th. And so as to those violations, counsel,
Your Honor, my client prepared to plead guilty of the bond violation with explanation.
all right. And so ma'am, as those violations, how do you plead?
I plead guilty. And my friend died that day.
And you've, just one moment, please, ma'am. You've gone over your advice of rights with your attorney, correct? And you understand that you have the right to have a contested hearing in this matter. And by entering into a plea, you will not have that contested hearing. Do you understand that?
Yes, I do.
Okay. Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No,
And you understand the possible penalty as a result of your plea?
believe so, yes.
Okay, this court could revoke your bond, the court could send you to jail, the court could not send you to jail, the court could give you a fine, a mix of all of that. Do you understand?
Yes, I do.
And knowing all that, you want to continue with your plea.
Yes.
All right. And counsel, if you can please pardon your client.
Yes, Ms. Daines, you've heard the allegation, you've read the allegations of the probation department that on the 22nd of March that you tested positive for certain drugs. Do you admit that?
I do.
And likewise, 7 days later, similar result, level reduced, 329.24. Do you acknowledge that you tested positive for those things?
It says I did, I did.
And then again, on 4/15/24, they allege that you failed to appear. You acknowledge that you failed to appear?
I do.
You have an explanation for that, but you do acknowledge that you failed to appear.
I do.
All right. The court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea of guilty to the bond violations. And counsel, why should I not sentence your client to jail for the bond violations, multiple bond
As
violations?
she's indicated, this is so close in time to the time of her sentencing. She prepared to test today, working backwards from today. She tested on the 3rd and on the 10th, and only Suboxone. So there's other things that have been cleared from her system. Suboxone she has a prescription for. On the 15th, she may be better to explain. There is, I think there's verification attached with the bond violation. She did, well, it's a little bit confusing. She did attempt, or she did call and indicate that she had a problem getting there on the 15th. There is a note from the probation department indicating that she had called the Lincoln Park office and said the door was locked. They state the door was not locked, but apparently it may be a different door. We're referring to whether the door was new paint on the door. She did call 727. Apparently they closed at 7. And she also sent an email.
To the court.
Maybe she could explain it a little bit clearer.
No, it was sent on April 16th, and there was a whole lot of stuff apparently going on the 15th. But ma'am, let me just say this, okay? You need to put yourself first and your sobriety first. Missing tests because of a friend being sick, and you're the only one that was able to visit him. No, you have two things in here.
Yeah.
One, a friend,
I'm his caregiver and.
a friend passed away from eating a cannoli.
With peanuts, yes.
And then the other one was your roommate was sick. And then he spent 2 days in Wyandotte Hospital and was released the day you had to test. So, well, I understand that life events happen, okay? You have multiple times during the day to test, first thing in the morning or in the evening. That has to be your priority.
I asked if I could make it up and nobody got back to me.
Ma'am, you have to make it a priority. Because a missed test is considered a positive test. And individuals miss a test because sometimes they miss a test for legitimate reasons, sometimes they miss a test because they think they're gonna test dirty or positive, and then they wanna have a makeup test later because now they know they're not gonna test positive. So make it a priority to make your tests. Now, you did state, if I recall correctly, that you would test positive for cocaine on March 20th, okay? Your level on March 22nd for cocaine was lower than your level on March 29th. That's how I know there was new use. There was new use, ma'am.
I swear on my life, absolutely not.
Because on your presumptive positive on March 22nd, which is 150 nanograms per milliliter cutoff, okay? So you're right around there. Then on March 29, you were at 202 nanograms per milliliter. So that's where it shows new use.
Absolutely not. I've been clean and sober, and I've never been happier in my life. I'm sorry, Judge. I don't know why that is. I really don't. I really don't.
I'm sorry, please, I can't have you speak from in the court because nobody, you're not identified for the record.
I could test today. I'm very sure. I haven't missed it. I fought the wagon for a couple of weeks, but I've been pretty clean and sober for 4 years. And I had a bunch of stuff happen with this legal stuff, but I'm back to my sober life. And I've never been happier. Honest to God. It even says on the front page that the level's reduced.
On your marijuana, yes.
Oh, okay.
Your cocaine numbers went up. Well, the medication that you take, are you getting it from a pharmacy or are you getting it from somebody else?
Suboxone? Pharmacy.
Okay. What about the amphetamine that you took?
I don't know what that is.
Okay.
What's the drug name?
It just says amphetamine.
Could have been cocaine? I don't know. I'm not taking any street drugs or buying anything illegal. I'm in outpatient therapy, just had it 2 days ago with counseling. I'm trying to stay sober for my son and myself. I'm trying to have a good life. I mean,
I understand that.
I did not reuse. I swear to you, I did not use again.
Well, ma'am,
I'm not going to risk my freedom for that.
the numbers show that there is new use. Here's what I'm going to do, okay? I'm going to order on the bond violation 10 days jail. I'm going to suspend that jail. I'm also going to order on the sentencing that there's reasonable grounds to Department of MCL 769.5 after hearing from Ms. Daines, hearing from counsel, reviewing the report, the recommendation, the bond violation. The court's going to order 24 months probation. I'm going to order the following conditions. You are, and the court will also note that you're eligible for early discharge. You're also eligible under 25.136B. The court's going to order the following. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not using any alcohol or drugs unless prescribed, and you'll continue to have random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to order 45 days jail. I'm going to suspend that jail as well. So ma'am, what that means is that your jail right now is going to be suspended. If there's violations, you'll be serving that time. Okay, so whether or not you serve jail time is 100% in your control. You do. Put yourself first. Don't put other people's problems or concerns ahead of yours, because they're not the ones that are going to end up being in the Wayne County Jail. Okay? Your Honor. And we're going to do a jail review on both the bond violation and the jail review on the sentencing for the 45 days. We'll do this June. We'll do June 3rd. I don't want to go too far out. All right, at 9:45 a.m. All right, and also you are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so that you are able to maintain sobriety and prevent relapse. You are to participate in fan meetings once per month. The rehabilitative goal for that condition is to allow you additional support network and recovery resources. And you also are to perform 80 hours of community service. The rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community. And ma'am, I understand that you're employed by DoorDash. I think that you may need to have a bit more stable employment, which would, okay. So I'm also going to order you to seek and maintain employment and provide proof of completing 20 job applications per week. Okay. All right. Any questions regarding the conditions?
No.
All right. The court's going to order a $400 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. Since you're eligible for early discharge, up to $600 of that may not be due. $300 for the cost of prosecution. Crime victim assessment fee, $75. Justice system assessment fee of $50. $2,125 is the total between both, or is the total for your fines and costs. You did post a $150 bond. Do you have any other money to pay today?
Sure do.
How much is that, ma'am?
$400.
Okay, so the court will order a total of $550 when you apply your bond and the $400 that you have to pay today. And then that will be that will leave a balance of $1,575. Can you do $100 per month? What date of the month works best?
The first is fine.
All right. Since you're paying $400, are you still able to do that May 1st, or do you want to start that June 1st?
June 1st will be better.
Okay. All right, since I did indicate, ma'am, that you're eligible under for early discharge, so long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort for making full payment. Okay? Good luck to you, ma'am. Please have a seat over in probation and somebody will be with you shortly. And this is the matter of the city of Wyandotte versus Matthew Stevenson, 24177.
Right here.